of the Randwick Local Planning Panel on 11 April 2024. First, I would like to acknowledge that we are meeting on the land of the Bidjigal and the Gadigal peoples who occupy the Sydney coast, being the traditional owners. On behalf of Randwick Council, I acknowledge and pay my respects to the elders past and present and to Aboriginal people in attendance today. My name is Graham Brown. I'm the chair of the panel, and joining me today are Helena Miller and Brendan Randles as experts, and community representative is Edna Gregorio. Each panel member has filled out a declaration of interest, and I will ask each member to indicate whether they have a conflict of interest.
No conflicts for me.
Okay. No conflicts for me.
Yeah.
Thank you, Brian. Also, thank you for the acknowledgement. I would like to acknowledge we are Bidjigal and Gadigal people, and pay my respects to the elders past and present, and no conflict.
Thank you. The panel members have undertaken site inspections on the items on today's agenda. And today we have a number of speakers registered to address the panel. The two items in the public meeting are D26/24, 30 to 32 Moore Street, Coogee, and D26/24, 54 Broome Street, Coogee. Speakers will be heard for each item in the public meeting agenda in the following order: 1, councillors; 2, objector or representative speaking against the application; and then the applicant or the applicant's representative speaking for the application. Each speaker will be given 3 minutes to address the panel. A warning bell will be given when there are 30 seconds left. The panel has been provided with copies of all submissions received in response to the public exhibition of the application. Therefore, there is no need for speakers to repeat all the points made in those submissions, but just the key matters you wish us to understand and to consider, including any suggestions about how your concerns could be resolved. The applicant may wish to comment on issues raised in the council's report, provide a response to proposed conditions, and or address any issues raised by an objector or councillor. After the speaker has addressed the panel, panel members may ask the speaker questions to clarify the matters. Questions and comments cannot be made from the gallery. If you interject on any matter from the gallery, you may be asked to leave the meeting. Only registered speakers will be allowed to speak and respond to questions from the chair or other panel members. An audio recording is being made of this meeting, and we will ask that speakers use the microphone if attending in person when addressing the panel to ensure that the comments are recorded. The audio recording will be available through Council's website tomorrow afternoon. After the registered speakers for each item have been heard, the meeting will be adjourned for the panel to deliberate. The panel will then reconvene for determination if that is the course chosen by the panel. The first item is D25/24, being 30 to 32 Moore Street, Coogee. The first person to speak to the panel is Matt Koskinen. Is that correct? Are you there, Matt?
Thank you.
Yes.
Share screen.
Could you proceed, please, Matt?
Sure. Can you see this? Can you see this?
Yes.
I sent it through to
Yes.
council as well, so you'd have it in the submissions email.
Yes.
Okay. So good afternoon, everyone. I'm the immediate neighbor at 28 Moore Street and representing a few other neighbors as well. Overall, the original proposal was offensive, and as evidenced by the 21 submissions raising 29 separate individual concerns. I think the council's done an excellent job in finding balance in all of this. And for today, although I'm listed as a speaker against the proposal, not actually against the proposal or the development, I think it's approaching a sensible outcome. However, I do have three key concerns I'd like to raise with the panel today, being clarification of the final approval and what is actually being built, 2 minor modification requests, and 3 additional conditions. So starting with number 1 and looking at the materials sent through, what is being approved? The current proposal submitted is a Frankenstein of images and plans that don't correspond with each other, and there's no summary of the final proposal that's been given to the panel for consideration. The request is pretty simple, is delay approval until we have documents and plans that are concise and consistent alongside scale with the correct scale of the properties in the surrounding area. Second point on minor modifications, which is tied to clarifications. The revised plans include a setback on level 2, which I think addresses a number of the concerns originally raised. So thank you for that consideration. However, with level 1 patio, which I'll come to at the end, it's unclear as how that's positioned relative to 28 Moore Street. And there's a chance that based on some of the images, but not all, is that they can look directly into our living space. And we're generally okay if it's transient, going up and down stairs or walking around. But the concern is if there's like a fixed seated area looking right into our space. Again, it goes to number 1 with what is being approved. And then last is just around additional conditions, largely to do with safety, which is a real concern for with us. So turning to the second page on additional conditions, the first is pretty straightforward. It's just making sure that what is approved ultimately is what is going to be built. We see this in some areas that I work in. I work in commercial real estate, that minor variations morph into a different outcome. So the request is really to have upfront consistency with what is being approved on the back end. The second is probably our biggest concern. It's with safety. So given the age of the building, there's a good chance asbestos is going to be found, and how that is managed is critically important to us. We have a 2-year-old and a newborn. We're about 2 to 3 meters away. The language in the document is generic copy and paste asbestos kind of safety precautions. So what we request is something along the lines of a requirement to notify neighbors and council immediately if it isn't discovered, and then subject to the highest standard of safety on removal, provide neighbors with sufficient notice to take action if they deem appropriate. It's also an environmentally sensitive area on the coastal walk with oceanside with gusty winds, so it's a real concern. The second is in demolition and jackhammering. Again, we're a family right next door. The timelines presented are challenging for a 2-year-old and a newborn for naps, for just living there. We don't have anywhere else to go. So the request is really to restrict 6 hours a day maximum for the heavy kind of decibel level activities. And then last is dust and seepage control, again, related to asbestos, with conditions largely simple around managing it to a sufficient standard of safety consistent with the area, given the environmental concerns as well. The third is hopefully not required, is just, what happens in the event they can't do this in a safe manner? And if we have to leave our home, I don't think it's reasonable that we would have to be basically incur financial hardship for their issues. So it's an insurable event if they get the appropriate coverage up front, and just something to consider for the panel. The fourth is relation to visual bulk, and figure 11 in the materials basically shows that we're going to be faced with a big concrete gray wall over 3 stories that looks like a prison yard. We're requesting that the western side of that, the visual bulk be softened similar to the eastern side. So it has like a green wall look and feel. And then the other final concerns here with regards to privacy shutters on the glass, kind of is going to face the Moore Street, the major street, in particular 2A, to have the appropriate amount of privacy. And then any consequences for repeat appending, because the reality is they're going to have issues here and there, which is fine. It's just if they have, they're careless in that regard, some consequences, not just a small little fine that they might just accept. And then the last one is just a request if they can sync power lines. I don't know if that's part of this proposal or not, to give something back to the neighborhood as part of this overall. So I'll leave it there. Thank you very much for your time today. Appreciate everything the council's done thus far and balancing out the original proposal and where this has gotten to. Thank you.
Okay, thank you, Matt. If you can just hold on to see if any of the panel members have any questions.
Not from me.
Nothing from me. No. Thank you.
Okay, thank you, Matt, for your time. The representative from the applicant, Mr. Anthony Petros, please.
Thank you, panel. Firstly, panel, I'd like to request panel support the recommendation for approval. We've been through the conditions and note that some of those conditions address the request made by the previous speaker. You will note that the west-facing windows on each level are required to have a privacy treatment, which I think is a good idea for mutual privacy to the western neighbour at number 28 as well. There are quite a few conditions which require demolition and construction plan of management. Condition 34, dilapidation report is also included there, and there are other conditions regarding vibration monitoring, etc. And there's also a seepage condition. So I think council's conditions suitably pick up the other concerns as raised. I understand a concern was also raised on behalf of the rear neighbour at number 2A Major Street. The rear of the building is over 12 metres from that boundary, and then their windows are even further again. And as you would have seen from site, there is a considerable degree of mutual overlooking. In terms of the height variation, I think council's report has covered that adequately in terms of the 4.6. And as you can see, it's not having much of an impact at all. All views have been retained and somewhat improved from some instances through the increased rear setback compared to the existing building. There's no adverse shadow impacts or privacy impacts associated with that. There's also a condition requesting a planter box be provided on the western side of the uppermost balcony as well. And I think that also goes towards addressing the concerns raised by number 28 and 2A to a degree. I'm happy to answer any questions.
Okay, thank you. Panel members?
Yeah, look, I'll ask you a question, Anthony, even though I would have directed it to the architect. What advice have you received currently about potential fire issues to the west-facing fenestration, especially from the bedroom?
Yeah, they're within 3 metres, and I understand it's a Class 2 building. I'm not sure if the building would need to be sprinkled. Sorry, I'd have to defer to that. I'll check the conditions if there's a BCA compliance condition, which I believe there is under condition 33.
The worry I have is that without knowing what you're proposing, we also know that a bedroom, it's an apartment building, a bedroom has a requirement under the ADG to have adequate ventilation and light. And if the BCA requirements actually then compromise that, you could be left with a building that's got approval, but in fact it's got closed windows to a bedroom. Did the architect ever consider putting that third bedroom on the other side of the building? Most people would actually prioritise having the bedrooms with views and put the bathroom on that side of the building, for example. Then you wouldn't have an issue at all, including an issue with with privacy.
No, I can't answer that. It did go to the design excellence panel, but from memory that point wasn't raised. I know there was a concern raised about its level of amenity, and the extra window was provided there. But I see a point about the fire rating to that window. There is another flat building just up the road. Sorry, just
and the other issue would be about the landscape. Oh, sorry about that, Anthony. I thought you were saying.
Oh, sorry. There is another building just at number 20 Moore Street, which has the same issues, and I think they may have got a fire rating, a fire engineered solution for those. Whether the building be sprinkled or otherwise, I can't recall, but I can show you on an aerial if you like where that flat building is.
It's more the case that the bedrooms end up with adequate light and ventilation and a resolved fire solution. Now, in terms of the issue brought up by the previous speaker, do you know what landscape is being proposed along the western side of the building?
No, I think there's an original landscape plan. Yeah, do you mean the western side adjoining number 28?
That's right.
It's quite a narrow area, and I don't think anything like
I think it's 2 metres wide. Yeah. So it looks as though there's adequate area there to depending on the depth of planting you're providing, to provide even some little tree, some, you know, some substantial landscape along there.
Yeah, it'd have to be something. I'll show you the landscape plan doesn't show anything in that western side. Yeah, I don't think much would grow down there personally, given it would be quite overshadowed by the respective buildings. But if there was some species that would, you know, shade tolerant species in the coastal area, we'd be happy to include that.
Okay, thank you.
Thank you.
Helen, any questions for Ms. Bedros?
None from me. No problem.
Thank you. Thank you, Anthony.
Thank you very much, and thanks for attending early today. Thank you.
They are the speakers for the first item. The second item, D26/24 54B Broome Street, Coogee. I'll have Mr. Steve Hoyles, is it? As an objector. Are you there, Steve?
Yes, I'm there, guys.
Yes. Steve, you have 3 minutes if you want to tell the panel what your concerns are.
Yep. Thanks for hearing me out, guys. So yeah, look, I'm a lifetime resident of Broome Street, Coogee. I live on number 25, as have my parents the whole life. They're next door to me, and my sister's next door to them. So my situation is slightly unique in this, and I've been really transparent with the landlord and the tenant in the reasons for my objection. So in 2018 or 19, I actually went through a CDC with this exact same space to try and have it used as permissible recreational facility space in the exact same location that we're talking about at the moment. We were given that CDC was approved, and we were given a CC from a certifier, and then subsequently paid a deposit on the lease, and all those all the works you see that are completed in that space that's never been used. There's a current gym floor track, there's a bathroom, there's tiling, there's ventilation. That's all been done at my expense. So then midway through the build, we were told that it was needed to be shut down because it was storage or void space, and it was never to be considered for anything other than that. So long story short, without trying to bore you, my position is simply this. I'm almost $200,000 in debt to that landlord, who still has my deposit of $46,000 and who knows that he's got my deposit, yet he's still out there trying to lease out that space. So we went through a long process in trying to chase him and get our money back, and it was just clear to us it was becoming too expensive to chase the money that we were owed. So my position is, I don't have a problem with this being approved as a resident of the street. I'm in a similar industry. I don't have an issue with this tenant taking on this lease and having a business that is similar to mine up the road on Coogee Bay Road. My position is I'm going to have to go legal against the landlord, and he's already told me to not object, and if we could sort of try and sort something out on the side. I've got zero faith that the landlord would actually do that, because I've been trying to chase our refunded deposit for a long period of time. So yeah, that's quite simply my position. I've got all the evidence of the bills being spent, the deposit being paid. And I went to him when I saw this DA and said, look, I'm going to object if you don't pay me my money back. And he said, oh, well, I'm not going to. It's a he said, she said. But the latest conversation was, well, I'm not going to pay your money back because I don't know if it's going to be approved. If it's approved, we can talk. And I just thought that was pretty unethical. So,
Mr. Hoyles, can I just interrupt you? You understand that this is a planning application, and the issues you've raised are essentially private issues.
Well, they are private, but I have spoken to the council a number of times and it's gone nowhere. So I do understand this is a planning issue, but I don't know how else I can get. I just wanted the council to know that if it does go ahead and there's any type of challenge towards the landlord, and you guys are the council that oversee this. So I had a CDC rejected. I then had a DA rejected that the landlord had submitted on my behalf without me knowing. So I find it curious from a planning point of view how CDC can be shut down, then a DA can be rejected, and 3 years later the exact same space can be put through the same process and it can be approved. So from a planning point of view, I do find it curious as to how I was let to go so far down the road, and then it now comes up again and it's in discussion for being approved. So I do
I mean,
find it curious from
Can
a
I say
planning
that
point
the
of view.
CDC issues are probably separate to what we're dealing with today? What we're dealing with today is the use of the area rather than the legalities of how it was constructed. Now, the application is only to use that area. It doesn't involve the matters that you've raised, unfortunately for you, but we're limited in terms of what we can do with this application. We're bound by the Act that gives us not so much guidelines, but specific issues we can consider in terms of determining this development application.
Yeah, understood that. And so can I ask why then a follow-on DA application was rejected? I know there's been at least one, potentially more, on this location, and why this one's different to other ones?
You'll have to take that up with the council because we're an independent panel that's only looking at this application. Apart from a general history that was in the report, we're not aware of the particular circumstances that led to previous rejections or approvals of other matters there. I mean, if you wish to, you could take it up with the council, but it's certainly not something that we can deal with, I'm afraid.
Okay, look, I appreciate that. Again, I was trying to be really clear with my contacts to the council about where the next step should be, and I was led in this direction. So it appears I'll have to go somewhere else.
I mean, I don't want to lead you up the garden path and you thinking that we have some power to deal with your dispute because we don't, I'm afraid.
No, that's okay. I'm sure someone will, but that's how people like this developer get away with these things, because no one challenges them.
Okay. Now, is there anything else you wanted to say?
No, I'm all good. Thank you.
Okay.
Thanks for your time.
Members, anything?
No.
No, thank
No,
you.
from me, thank you.
Thank you for your time. I understand your position, but unfortunately, we're not in a position to be involved in that sort of dispute between you and the land.
That's okay. Thank you.
Okay, thank you for your time. The applicant is represented by Mr. George Caravanis. George, are you there?
Yes, I am, Mr. Chair. Thank you for giving me the opportunity to address you today. I am speaking on behalf of the applicant in support of the application, and I have with me Mr. Aaron Tomlins from McLaren Engineering, Traffic Engineering, who's our traffic engineer, and he's available to answer any questions of the panel should they have some. On behalf of the applicant, I'd like to confirm that we do concur with the thorough assessment contained in the council officer's report and the recommendation, and of course we are not challenging any of the recommended conditions of consent. As you would be aware, the proposal is for the following works: for the conversion of the lower ground storage area into a warm-up, cool-down and recovery area with some associated facilities, and they are ancillary to the existing gym at the ground level. You may also be aware that the proposed works are all contained within the existing building envelope, and there are no bulk and scale issues or built form amenity impacts resulting from it. Members of the panel, this is an important addition to the gym as warm-up and recovery sessions are becoming as significant as the workouts themselves, particularly with the age group of patrons increasing. Older people like myself need to ensure that they do the correct warm-up and recovery sessions to avoid injury and get more out of their training sessions. So it's very important to have those facilities to in the building itself. The proposed works are permissible in the RE1 zone, and there are no development standards that are applicable or breached. Given the minor nature of the proposal and the internalised situation, most of the DCP is not relevant, with the exception perhaps of Part B7, which stipulates the car parking rates for the development. In this regard, a traffic report has been prepared by McLaren Traffic Engineering and has been assessed and supported by Council's traffic engineer. In the traffic report, our traffic engineer concludes that the application should not significantly impact the availability of on-street car parking, as the application is catering for patrons of the gym with the improved facilities. As indicated, I have our traffic engineer here, should there be any questions of him. We've also done a BCA and access capability statement, and that's been prepared by Design Confidence. That's been reviewed by Council's compliance officer and has been supported. Indeed, an acoustic report has also been prepared by Acoustic Logic, and that's been reviewed and supported by Council's Environmental Health Officer. So, members of the panel, the application before you, as conditions, will not adversely affect the amenity of the other tenants in the building or indeed the surrounding development by way of loss of parking, acoustic impacts, or building compliance. It's an important addition to the community, and it has been thoroughly documented and assessed by Council's officers. It's for these reasons, members of the panel, that the proposal is appropriate from a planning, traffic and compliance point of view. As correctly stated by the chair, the matters raised by the objector are not planning matters, they're private matters. I'm sure there's another side to that story, but as I said, it's not something for me to comment on. It is a private matter. We're happy to answer any questions. Thank you.
Thank you. Panel members, any questions of Mr. Karavanis or the traffic engineer?
No.
No question.
No, I think we're content, Mr. Karavanis. Thank you for your
Thank you,
time.
Mr. Chair. Thank you.
There being no further speakers, I declare the meeting closed at 1:28